is the Criminal Division of the High Court. Today we had two major cases in the judiciary or in the courts of law. We had Dr. Sarah Bireete's case earlier in the morning at Buganda Road Court. Dr. Sarah Bireete was produced, and then she was further remanded until January 28th of this month. Actually, this is next week. So she applied for bail, but the prosecution was objecting to her bail application, saying that there is no evidence that Luzira cannot handle her condition in which she is in right now. Dr. Sarah says that she is suffering from pressure and therefore she is hypertensive. But then the prosecution, which was being represented by Joan Kepo, Chief State Attorney, said that there is no evidence that Luzira cannot handle her condition. So the magistrate asked to be given more time so that she can analyze through all the submissions that were made by both parties. Dr. Sarah Bireete was represented by Counsel Judy Lyamukama, who said that very soon she's going to challenge the charges that were levied against her because of lack of jurisdiction. Counsel Judy Lyamukama is yet to put in that application, and then afterwards the magistrate is going to be deciding on her position next week.
Good morning. Criminal case number 001 of 2026, Uganda versus Sarah Bireete.
Your Worship, this matter was adjourned to today, 21st, for the prosecution to make a reply on the application for bail that was made by the defendant. We are ready with our reply. We pray to proceed.
Can we proceed?
Much obliged, Your Worship. The application, Your Worship, was a brief one, and so will our reply be. Your Worship, in the bundle of documents that the defense provided this court, one of them was a medical report issued for the applicant from Platinum Specialist Hospital. The report, Your Worship, is dated 2nd January 2026. I will not divulge into the contents because it's on court record of the reports. However, Your Worship, for medical grounds to serve as a basis for grant of bail, there must be proof that the prison service cannot manage the given condition of the accused person or the applicant. There must be proof that the prison service, medical service, cannot manage the condition, the medical condition of the applicant or the accused person. Your Worship, in the case of Tigawalana Bakali, which is criminal case number 0161 of 2023, criminal case number 0161 of 2023. Your Worship, in this case, the High Court declined to grant bail on the grounds that the applicant in the case had not satisfied court that the illness they were complaining about was incapable of being treated in the prison while in prison's custody. That the applicant had not adduced evidence to the satisfaction of court that he is suffering from such grave illness which cannot be treated in the prison service, medical service. Your Worship, also in the case of Mugera John, it's a miscellaneous application number 21 of 2023. Actually, court denied bail in this case on the basis that the prisons had confirmed that they can manage the illness of the applicant. Your worship, to rely on medical grounds as for the grant of bail, this must be proved. There must be evidence that the prisons cannot manage the illness or the medical condition of the applicant, which has not been proved in this case. And it's our prayer that this ground should not be relied on for the grant of bail. Your worship, during the application by the defense, counsel submitted that this is a document-based case and that the applicant has no witnesses to tamper with. Your worship, logic dictates that this is a prosecution case. We have not disclosed to the defense. And the fact of interference cannot be assumed by the defense. The prosecution that knows who they intend to call to prove their case. Your worship, considering the status of the applicant, an executive director of a very big organization, she's in position and very capable of interfering with the prosecution witnesses. This need no affidavit to prove, just by the particulars, your worship. Of the applicant, he is powerful with stature and capable of interfering with the witnesses. It's therefore not true that this is a document-based case that has no witnesses to interfere with, and therefore we pray that this honorable court disregards the submissions of the defense in that line. Your worship, I'll move to the substantiality of the sureties. The applicant presented court with 4 sureties. The first surety, Bayenga Joseph, he presented an employment ID, your worship, that he is the managing director of Power FM. Your worship, with his documents, he did not furnish court with anything, any proof that he has the ability to meet any monetary obligations in case ordered to forfeit a bond. We saw none of the same, and the same must be proved with evidence. Being a managing director of Power FM is not conclusive that he has the ability to financially meet any monetary obligation in the event of a bond to be forfeited. The second surety, your worship, Miss Kiza, Honorable Kiza Winfred, your worship, she was very ably introduced as the former leader of opposition and former member of parliament. Catchword, former, your worship. Your worship, no evidence has been adduced to show that she has any credible source of income or is gainfully employed anywhere or existence of any asset, your worship, that she can be said to have the ability, your worship, in the event of any forfeit of a bond, to pay it comfortably. The third surety, Otieno Joseph, was also introduced. In his words, he said, I am the would-be president of UPC. Your worship, I know of no such job. Maybe I'm mistaken. However, it is clear that he is not gainfully employed unless the same was not adduced to this court. neither have they furnished any assets. UPC party. He is clearly, Your Worship, not gainfully employed or in possession of any assets that have been brought before court to confirm that in the event of abscondment, he has the capacity to forfeit a bond. The fourth surety, Your Worship, Ambassador Sempala Edith, was also introduced as a retired ambassador to the US. I will repeat, retired ambassador to the US, with emphasis on retired. Your Worship, we have also not been furnished with any proof that the surety is gainfully employed or possesses any assets. Or has a credible source of income to warrant her to be a substantial surety. You are not submitting without authority. That said, I pray to refer to what bail is, who a surety is, and what security is. Your Worship, the bail guidelines as they are referred to, but in full the constitutional bail guidelines for courts of judicature, practice directions of 2022, paragraph 4 defines bail. I will not read verbatim, I will only highlight, because we have the law, I will only highlight my points of interest in these definitions. Bail means temporary release of an accused person after providing security for future appearance in court. Security that is referred to in the definition of bail means a sum of money or property pledged or deposited in court in exchange for release of an accused person. That is what security means according to the law. That is paragraph 4. Your Worship, the same law defines a surety to be a person who undertakes to ensure the applicant will appear in court and who furnishes security. That money and asset we are referring to is the security that the surety must furnish to court before the grant of bail. To make it even clearer, Your Worship, a substantial surety is defined in the case of Aganyira Albert versus Uganda. It is criminal misdemeanor application number 71 of 2013. The ruling is not numbered, pages are not numbered, but it defines a substantial surety as having real worth and importance. This, in my opinion, means value in terms of status, reputation, and good standing economically endowed. So, Your Worship, the issue of the economic standard of a surety is not something that you should underestimate, because bail is a contract between court, applicant, and the surety. And breach thereof attracts payment or forfeit of a bond. Therefore, the person standing surety must be able to furnish that bond, or at least provide proof that they can furnish that bond. Your Worship, still in the case of Aganyira Albert, it is mentioned subsequently that proof of substantiality of the surety calls for documentary evidence of facts to prove capacity to meet monetary obligations. And court went on to give an example that proof of ownership of property can be attached and sold is proof of evidential value. Your Worship, it is not a joke that we come and stand surety when we cannot afford to forfeit a bond. Also, in the two cases, they are distinguished. Both of Mugera John, but different applications. 002 of 2022 miscellaneous application and 021 of 2023. Both those cases indicate that sureties should have some credible source of income. It is even not fair to tie a rope of being surety around the neck of someone who is not having the capacity to forfeit a bond in the event of abscondment. Like I said, my response is short because the application was short. In conclusion, Your Worship, from the foregoing, in the absence of substantial sureties, which in our opinion, the sureties provided are not substantial, we pray that this application is dismissed. And the accused person's bail is denied. We so pray on.
Firstly, Your Honor, as we listen to the objections of the state, it is imperative that we remind the court that bail is founded on the constitutional presumption of innocence under Article 28 clause 3. Any person charged with an offense is presumed innocent until proven guilty or they plead guilty. And the state seems to suggest that what you have before the court, that it is a body. The presumption of innocence means something. And one of the things that the presumption of innocence means is that a person who has been charged should not be treated like a convict. Secondly, Your Honor, we have had guidance from the Constitutional Court about the meaning of Article 23.6a on the right to apply for bail. And the Constitutional Court, specifically in the Constitutional Reference, the Constitutional Court in Reference 20, Constitutional Reference 20 of 2005, DPP versus Dr. Resident, Constitutional Reference 20 of 2005, the Constitutional Court unanimously emphasized that the right to apply for bail should not be fettered by unreasonable and stringent requirements. Because the right to apply for bail is founded on a presumption of innocence. And therefore, the requirements which the state demands for must be seen in that light. If this particular constitution means anything, if Article 23.6a means anything, if Article 28 clause 3a means anything, if the presumption of innocence exists, it was intended for situations like this. Otherwise, it's useless and meaningless. For us to say there is a presumption of innocence, if a person who has been charged, has not been tried, can be detained and remanded in prison as a convict, and the state is arguing that that status quo is ideal. Your Honor, I will invite the court to make a careful reading of that reference, DPP versus Cameroon's Constitutional Reference 20 of 2005. It emphasizes that the key criteria, the question that the court should ask itself is, will this accused person abscond if she's on bail? Is she going to run away? Or is she available for trial? And the others are irrelevant considerations. And that is why the Constitutional Court in another matter, Foundation for Human Rights Initiative versus Attorney General, the Constitutional Court, again, unanimously pointed out that even the bail requirements in the Magistrate's Courts Act and the Trial Indictment Act are guidelines. It's not mandatory that they should exist for an accused person to be granted bail. Why? Because there is a presumption of innocence. What is the interest of the court with an accused person? The interest is that the accused person able to present herself for trial. That is all. These other sentiments that the state brings must have evidence. The learned prosecutor is advancing the theory that the accused person is a person of substantial means, that we can all recognize it. Of course, that is speculation. And funny enough, the same learned prosecutor thinks a former leader of opposition, a former chief whip in parliament, a member of parliament for over 10 years, is not a substantial person. Your Honor, we can't take that as a serious submission. Your Honor, we turn to the guidelines, the bail guidelines. Fortunately, the state agrees that we should all take some recourse to the bail guidelines. But these are guidelines. The Constitution bail guidelines for court of people. Not to take the court's time, let's go quickly through paragraph 15 of the bail guidelines. Paragraph 15. Paragraph 15 is about determining suitability of a surety, because the state is objective to suitability of surety. It's on very fanciful theory. Paragraph 15 provides that when considering suitability of a surety, the court shall take into account. That alone is also indicates that these are considerations. They are not mandatory, but the court can take into account the age of the surety, work and residence of the surety, character and antecedents of the surety, relationship to the accused person, and any other factor as the court may use. There is nothing about a surety proving that they are extremely wealthy, as the prosecutor is saying. There is nothing of the sort. Subparagraph 2, I'm seeing paragraph 15 here, provides that subject to subparagraph 1, the proposed surety shall provide documentary proof, including the proposed surety shall provide documentary proof, including A, a copy of his or her national identity card, passport, or alien identification card. B, an introduction letter from the elsewhere chairperson of the area where the surety is ordinarily resident. Then O, C, asylum seeker or registration document. That's not very bad. In other words, the guidelines which we try to follow to assist the court are saying when a surety is required, present to the court a national ID or a passport, an introduction letter from an LC1. Then the court, using its good sense and reasonable discretion, takes into account these other factors: age, work residence, character, and antecedents of a surety. So, guideline 15 does not, in fact, provide for what the land prosecutor is advancing. And in fact, the court requiring an accused to provide surety happens after a decision is made. If the court grants bail and requires the accused person to deposit money, that's the security referred to in that definition. Security means the sum of money or property paid or deposited in court in exchange for release of an accused person. As the court ordered the accused to provide security and she had failed to do so? No. And therefore it's misleading to claim that this security must exist in advance, or that sureties must provide it in advance. Your Honor, sureties cannot second guess court. The guidelines, if the guidelines are clearly said the sureties should provide land titles and all. And by the way, Your Honor, these guidelines are different from, for example, the guidelines at the Anti-Corruption Division, which provide for what the state is asking for. These are general guidelines for all courts of judicature, and they are specific. Why? Because the nature of the offenses which are outside, the offenses under the ACP, the offense the accused is charged with, and lawful obtaining or disclosing of personal data. It's not a financial crime. The nature of the sentence that can be imposed is clear in the provision. And therefore, to require very stringent and unreasonable tests for sureties would be to disregard the bail guidelines, would be to disregard the Constitution. The accused person has the right to apply for bail. She exercised the right and applied. The state is trying to fetter that right with many unreasonable requirements that have no foundation, even in the bail guidelines devoted for the judiciary. Your Honor, it is therefore our view that on record, what's important, what's clear is that the sureties are substantial. A managing director of Power FM surely cannot be someone who will fail to meet obligations. The obligations of sureties, Your Honor, are provided in paragraph 16. Benefits from the presumption of innocence and that of the late prosecution and have right to apply for bail, and bail is granted on terms that this honorable court considers fair, reasonable, and just, taking into account that the accused has already spent now over 3 weeks in pretrial detention. And the state has already made it clear they have not disclosed to the defense anything. So we don't know whether we shall even have a criminal trial in this matter, but someone is on remand. This is not what the Constitution of this country envisages. And we therefore pray that this honorable court is pleased to grant the accused bail on the terms that it considers reasonable with the truth is represented. I so pray, Your Honor.
The submissions of both the defense for grant of bail, as well as the prosecution, have been heard by the court, as well as submissions in objection. Prosecution for the grant of bail and defense rejoinder to the same. Several decisions have been relied upon and law cited in argument by both the prosecution and the defense. The court shall refer to the same, analyze, and with arguments placed before it, determination for grant of bail for the accused person. The ruling in this application is deferred to the 28th of January 2026 at 9 a.m. Accused will be remanded till then.
We have been here for Sarah's application for bail, and you remember the other time, about 2 or 3 weeks ago, we applied for bail and we put the surety, but the magistrate refused to give bail and said he's going to consider the matter on 21st. They wrote to say on 21st. We came here knowing that today Sarah is going to get bail. Because why should she not get bail? Because according to the law of Uganda and according to the principles governing human rights in this country, every accused person is considered innocent until proved guilty. They are considered innocent until proved guilty. That is the principle. So that means that when you are arrested and you are accused, you are not a criminal, you are an accused person. That's why we have that word. You are an accused pending the time when evidence would be put forward to say that you did wrong. And then there, they will put you in prison. And prison you and sentence you. But in the meantime, because you are declared innocent until proved guilty, we have the law of applying for bail. And when you apply for bail, and your offense is bailable, we have what we call bailable offenses and non-bailable. Sarah's offense is bailable. It is an accusation which is bailable, that he got the personal information was it without permission? The charge is even awkward. It is awkward. And now, when we applied for bail that time, we put surety. We came today knowing that we are going to get Sarah out of on bail. But on listening to now, the state attorney came with very, very nonsensical reasons for objecting to bail. And one major one was that Sarah did not bring distinguished, I don't think she even said credible, she said distinguished rich people, that Sarah did not bring here rich people to stand for her. Because he said, and these sureties were very distinguished. You know, the former member of parliament for 2 terms and former leader of opposition. To be a leader of opposition in parliament is an alternative to speaker. And now that because she's retired now, she's no longer in holding positions like that. She is nobody, she is nothing, she has no money, she cannot stand for bail for Sarah. The other lady she talked about, and this woman is very, I don't know what to say. I don't know why President Museveni has really promoted women in positions to appear useless. You see, this is my problem. Because the state attorney is a woman, the judge, the magistrate is a woman, and they are demeaning distinguished women of caliber and integrity, like Honorable Winnie Chiza, like Her Excellency Edith Sempara, that distinguished woman. When President Museveni had taken over Kampala here and he ruled Uganda, that woman was a very effective ambassador in many countries, in Denmark, Norway, America, where I remember when we were struggling with her to secure this AGOA. We fought for AGOA, this thing of, and yet Uganda never benefited from it. But she used to take me to meet the ministers in America. She used to take me to see these big people in America, secure positions for Uganda here for support. And now she's retired back home in her dignified home. I mean, did this state attorney visit these distinguished ladies to see that they are poor and they don't have enough resources to stand security? Can you imagine demeaning such distinguished people? And that is the reason for not giving Sarah bail. And then also the magistrate, her worship. And she says, you go away, I will consider these things within a whole week. I mean, look here, the situation should have been, I have adjourned for afternoon. Let me go and consider the arguments from the prosecutor and from the defense, and in the afternoon I will come with my judgment. But she said, come back on 28th. Can you imagine these girls? I even call them girls. I'm not going to call them my daughters because my daughters are brilliant. They wouldn't do something like that. No, you cannot demean people like that. So for me, what I see, as I have already said, everybody is scared. The woman is, the prosecutor is scared. The magistrate is scared of losing her job or not getting promotion. And therefore, justice in Uganda, where is it? Why should Sarah really be suffering in prison? And I understand, by the way, that many more who were in politics there are about to be arrested and incarcerated. And therefore I end up by saying, you Ugandans, especially you police, all you need, all you know is to get the news and go and put it there. What more do you do?
As the makers of the Constitution, what does it tell you?
Which Constitution? I have told here many times that Constitution, which I personally participated in making right from the beginning to the end, has been today murdered, maimed. When you cripple, it has been crippled, has been shot down, has been injured, has been, I don't know, it is not there anymore.
We have appeared before the trial magistrate who is handling the matter of Dr. Sarah Bireete. Today the state was supposed to respond to our bail application for our client, Dr. Sarah Bireete. The state responded. The response really doesn't address what we consider to be the fundamental issues. And we brought it to the court's attention that the constitution of this country, if it is still in force and means anything, provides the right to an accused person to apply for bail. That's Article 23, Clause 6A. Then, the constitution of this country also provides for the presumption of innocence. In other words, an accused person who is charged with an offense is presumed to be innocent until they are proved guilty by the state or they plead guilty. Therefore, a court cannot remand a person in prison when they have not been convicted and when they have applied for bail. So the standards and the guidelines on which court is supposed to grant bail are very flexible and liberal. The main criteria is that this person who is granted bail should not run away. That is the only criteria, really, that the Constitution recognizes. To our surprise, after listening to those very simple arguments, both from us and from the state, the trial magistrate has again adjourned for a full week, apparently to write a bail ruling. The Chief Justice, the retired Chief Justice himself had made it clear that bail rulings should be delivered there and then, and maybe in the worst case scenarios the next day. But here 7 days are gone. So effectively, we are spending 1 full month on a bail application. And in the meantime, our client is in prison as if she is a convict. We think this is a very unfortunate abuse of the criminal justice system in this country. And if it continues like this, citizens are going to will continue to lose confidence in the courts of law. And that will be harmful both for the state and the individuals who think pre-trial detention of innocent accused persons is a normal routine, a normal administrative routine. It's very dangerous ground on which the court is treading by wanting to remand a person mechanically without any legal justification and contrary to the Constitution.
And you apply for a shorter time. Is it possible? Is it any?
When a judicial officer says they have adjourned for a ruling, they are indicating that for them they think they need a week to write the ruling, because we were all in the court. The magistrate didn't indicate whether this is a very complex matter that requires a full week to deliver a ruling. But we know that this is a straightforward issue. In any case, if the magistrate doesn't want to grant bail, he should say so right away, and we move on. Because the legal system has many options that we should be able to explore. But we are being denied an opportunity to explore the other legal options for Dr. Sarah Bireete by one court simply holding onto a matter and failing to process it. If the judicial officer decides not to grant bail, there are other options. But we need to get to that step as quickly as possible. And that is all we have been trying to impress on the court. And yes, we shall continue to explore other options and also to point out to the court that the management of this matter is seriously undermining public confidence in the ability of courts of law to be impartial. And this is dangerous for the judiciary as well. So we hope reason will prevail.